Welcome to Channel 17, the Town of Colonie Government Channel.
Hello and welcome to The Money Factor. I'm Richard Naylor, your host. The handshake is a symbol of a business agreement. But what's behind that agreement? Today we're going to be talking about business contracts and negotiating disputes. Our guests are Stuart, Klein, and Frank Mayer with Bond, Schoeneck King. I want to welcome you back to the show.
Thank you, Richard. It's good to be here.
We were happy to have you talk about business contracts in the recent past, but today we're going to talk about business law. Today we're going to be talking about contracts and what goes wrong and how to fix it, I guess.
Yes.
You want to give a little background first, though, on yourself and Bond, Schoeneck King?
Sure. Bond, Schoeneck King is a large regional law firm with offices across the state as well as in Florida. We have currently about 28 to 30 lawyers in the Albany office. We're a full practice firm. We provide business and counseling services, labor law services, litigation, intellectual property, and practice in most areas of the law. So we really are a one-stop shop for the practice of law. My particular practice area involves business transactions, tax, contract preparation, and analysis.
I admire the detail you guys put in. Stuart, how about you?
Sure. My name is Stuart Klein, and Richard, thank you very much for having us back here to put on this presentation. The type of work that I primarily handle is litigation-based work, which to everybody else is kind of considered the trial work. And more apropos to today's conversation dealing with business contracts and dispute resolution, I tend to handle business contracts when there has been a problem or there has been a disagreement. The whole purpose of a contract is to have a meeting of the minds and have an agreement. Sometimes things don't work out. So the perspective that I can lend is what happens when there is that clash or that dispute, and what can we do proactively to prevent that from happening.
Great. So there's the two parts of our show today. Let's start with the contract itself. There are many kind of contracts. I had one with lawn people over the summer. We mentioned that kind of a contract before. But when I start to think about it, there's a broad range. Could we kind of set the stage and talk about some of the range of contracts that you deal with?
Yes. I think for the purposes of the discussion today, Richard, we'll focus in on contracts between, let's say, a homeowner and a contractor, or maybe a contract between two businesses for the purchase of goods or services, those type of contracts. Since in our last discussion we talked about the purchase and sale of businesses, which is also a contract, but we're going to focus in today specifically on purchases of goods and services by individuals and by businesses.
Great. Now you can start with a contract that's maybe pre-done, or you could start with a blank sheet of paper, I guess. But when I think about a contract without really knowing a lot about the subject, it's totally mysterious to me how you come up with a contract. Could we go over the elements, if you could look at it that way? Are there elements, kind of abstract elements, that make up a contract?
There are, Richard. Think of a contract starting with the offer. I will sell you my blue Chevrolet. The acceptance being I agree to purchase the blue Chevrolet and not the red one. For consideration. The consideration is the exchange of a promise, the promise to purchase the automobile, the payment of a sum of money for the automobile. So you have an offer, you have an acceptance, and you have consideration, and you have a sufficient description of the necessary terms that go into the contract to form a contract. Obviously, there has to be an intent to form a contract that's legal and binding on the part of both parties. When that happens, we say that there's been a meeting of the minds of the parties.
Okay, and then the handshake, perhaps.
Then the handshake, perhaps. But sometimes a handshake isn't sufficient to memorialize an agreement, and there are certain contracts, Richard, which are required to be in writing.
Such as?
Well, There's the contract for the sale of real property. You know, you would never agree to purchase or sell a piece of real property that's not in writing. It's just not an enforceable agreement. There's the contract for the purchase of goods in excess of $500. That needs to be memorialized in writing.
Now, that would be between two individuals, not a store, of
or
course.
between a business, or between businesses as
Okay,
well.
okay.
Or between businesses as well. There'd be the contract for that cannot be performed within 1 year. For example, going back to your own example, if that agreement to care for your lawn was for 18 months, then that agreement would need to be in writing because it's a contract that's not capable of being performed within a year. And there's some other less common examples too, like an agreement to make a testamentary transfer by will, for example, needs to be in writing. Answering for the debt of another needs to be in writing for obvious reasons.
Is there any way to know what wouldn't have to be in writing? Because I think many people should err on the side of caution then.
Well, you know, again, there are those specific examples, but it comes really down to memorializing an agreement with a writing so that it's clear that the parties understand what the agreement is. Otherwise, Stuart's job becomes much more difficult.
Right, right.
And you know, I think one thing, Richard, going back to your example, and maybe we'll use that today as kind of our running, I guess the running thing to fall back to. If you had an arrangement with somebody to provide services at your residence for 18 months, and you did not have that in writing, you and that person may be going along and operating under the assumption that everything's fine and that you're going to pay that person for 18 months. But all of a sudden, on month 9, you change your mind and
It
say...
snows.
It snows, and you don't feel that you should pay this person any more money to mow your lawn,
Right.
or to rake leaves, because there's no need for that. At that point in time is when a dispute may arise. And you may tell the landscaper or whoever is providing the service, I feel that I don't need to pay you anymore. He may tell to you, say, Richard, we had an agreement that you were going to provide this to me for 18 months. Assuming that you were not able to negotiate this matter amicably amongst yourselves and lawyers were involved, the issue that would now be on the table would be whether or not there actually was a contract in the first place. And being that this type of contract was something that was lasting for more than 1 year, it would have to be in writing. And your potential defense would be, you know, Mr. Landscaper, notwithstanding the fact that I paid you for 9 months, we really never had an agreement in the first place. And therefore, I am not obligated to provide you or pay you for a going forward basis because there is no contract. So that being said, whether or not you actually have a contract, whether you have a handshake deal, whether you have a document in writing, the necessity for that in some instances will not arise until there is a problem.
Right.
A lot of times people entertain transactions or undertake business relationships without valid enforceable contracts, and there's no problem. So it's kind of the no harm, no foul.
Right.
It's what happens when there's the foul, so to speak, is that all of these elements become very, very important.
Or I guess unless something gets really imbalanced, like I've paid you 6 months and suddenly you can't, or I gave $30,000 for landscaping equipment and trees, but the guy never came back. So now I have a problem because it's not equal up to that point. You haven't done like a third of it and I've paid you a third. It's totally unbalanced. I'm way out and the person has a lot of my money.
It's very factually intensive. You know, I think each situation needs to be analyzed, each fact. And I think when Frank and I were here last time, one of the things when we were talking about in the business law genre is that nothing's really cookie cutter. Everything needs to fit each factual situation. And I know one of the things that you indicated that the viewers may be inquisitive about is what exactly should be in the contract. What should those terms be?
Right.
Assuming that you memorialize that contract in writing. And I think one of the things that should be in a contract is whatever you're trying to get out of the contract. So before you enter into that relationship with whoever the other person is, you are as clear as possible as to what you want to get out of it.
Right.
And what you may want to be the end result if there is a problem.
Right.
In other words, I think what Stuart is saying is that what are the obligations of the parties to perform, and when are they going to perform? What deliverables will there be? What am I going to do, Richard? What are you going to do? When are you going to do it? Will payment be made at the end? Will payment be made at milestone points? If there's a termination of the agreement prior to the completion of the contract, how much payment, if any, is due and owing?
Right.
If those things are memorialized in a writing, it makes it much clearer to resolve a dispute.
Because there's something to go by.
Yes.
Yeah, and going back to your example, to kind of dovetail what Frank just said, back to your lawn example. If you hire a landscaper to mow your lawn, but in your mind you think in the fall that also means rake leaves and clean the gutters, you want to make sure that that's memorialized in the agreement. That's specifically what you want to get out of it. You don't want, at the end of the day, there to be a dispute and two parties clashing over what a term means. You want to make sure that it is as clear, as crystal clear, to the extent anything is ever crystal clear, but that, a common person when reading that contract would say, oh, well, this clearly says mow lawn, clean gutters, and rake leaves.
And other terms within the contract, for example, who's going to provide the lawnmower, the gasoline? Who's going to provide the tools and assistance, if any?
What if it rains for 14 days, like a flood is coming?
Exactly. So, as Stuart said, the more clear we can make it as to who's going to do what and when, the better off all the parties will be and the less expensive it will be to resolve the dispute.
Okay. Before we move on to a next part, could you recap those three parts? I just want to make sure we've got them all clear.
Basically, the basic elements of a contract would be the offer.
Okay, so there you describe exactly what the product or service
That
is.
you're going to provide. And then there's the acceptance of the product or service, assuming that the offer, of course, isn't rejected and a counteroffer is made. But if there's an offer and there's an acceptance, we have that meeting of minds. It's for the sale of that red Chevrolet and not the blue Chevrolet.
Okay.
And the consideration, what's the price for the automobile going to be, and what are the payment terms? The consideration, again, being a payment of money, providing services, that type of thing.
I guess the bottom line here is it's got to be in writing and clear.
It should generally be in writing and clear. We did cover certain contracts which must be in writing, but I think Stuart and I will agree that every agreement or contract should be memorialized in a writing between the parties. It just makes it easier down the road.
Now you, as attorneys who do contracts, you know by experience many of the parts of a contract and many of the things that can go wrong. What do people overlook?
Well, a lot of things people overlook is the choice of law provision. And I think Stuart has a good story that he can share with you, the choice of law and choice of venue in a contract. In other words, what law will which state will the contract dispute be decided under, and where, in what court, for example, will the dispute be resolved?
I mean, one of the things is that you want to make sure is that you can kind of control your own destiny to some extent. And the choice of venue provision, which means basically if there is a dispute, where will this matter be heard, is something that I think a lot of people overlook, and sometimes it could come back to bite them, so to speak. For example, we have a client, an upstate New York client, and they entered into an agreement with an individual for the purchase of a product. And typically, a venue in New York is proper where either of the parties reside. Our client was an upstate entity. The purchaser, the customer, was from the New York City area. So they get into a dispute, and the person in New York City sues the vendor or our client down in a New York City court, requiring our client to travel 3 hours down to New York City for court conferences and things of that nature. There is ways potentially that the matter could be transferred back to upstate, but that's cost and time. But a simple line in the contract that would say, for example, any and all disputes arising based upon the terms of this contract would be venued in Albany County, would save the hardship of an entity from having to go down to downstate, for example, or spending money trying to get the case transferred back to upstate, so to
Right.
speak.
Yeah,
so there are little things that may not even cross one's mind because one isn't thinking about a problem. But if there is a problem, that one thing, for example, a venue provision, would insulate or protect the entity from having to travel to all ends of the earth to handle a dispute.
Which could disrupt more than just your bank account. A lot of time involved.
Exactly.
So I mean, even though the dispute in this case wasn't a large dispute, the cost to our client to travel to New York City and have counsel travel to New York City, outweighed the merits of the case,
So you really lost before you started.
essentially.
Sounds like a naive question, but where does the contract come from? Might be a good basis for a question, because a lot of times people are given a contract by one party. And normally that party knows what they're doing. They probably have attorneys, and they'll give it to maybe another business or a homeowner and say, here's a contract.
Well, a lot of times that is exactly what happens, Richard, and sometimes clients will come to us with a form agreement that either someone pulled off the internet, that someone had been using for years, that someone took and crossed items out from another vendor or landlord, and has tried to fashion it for the particular transaction at hand. Sometimes the contract is suitable for the transaction at hand, sometimes it isn't. And what we hope to be able to do is to help our clients formulate an agreement that's meaningful for the particular transaction at hand before they sign something.
Right.
So when they come to us with a draft agreement, then it's easy enough to help them. When they've already signed something and they've come in, that makes it more difficult to move forward in the direction that they would like to.
That's common sense, but I've heard it in other places where people would come to someone getting advice to find out if they made a good decision or not, and it's quite different
Exactly.
than whether they should make it.
I mean, and a lot of times too, Richard, is that people, whether they're small business owners or large business owners, they may get an agreement that is provided to them by the other entity, so to speak, and be in a position where they say, not a problem. I can, I don't need to get outside advice. It's too expensive to hire someone to review this contract. I'm just going to sign it anyway. And there's nothing that you can do to prevent somebody from doing that, but you can educate them as to what to look for in those situations. And from being involved in disputes where entities have signed agreements that have basically been passed across the table, one thing that tends to happen is that the entity that is submitting the contract for you to sign most likely will have language in the agreement that is favorable to it as opposed to the other side. One thing that I would recommend in those situations where individuals are deciding to handle things on their own is to make sure that whatever obligations that are imposed upon them are equally imposed upon the other side, so to speak. So it's kind of a mirror image, that it's not slanted more to one side to the other.
Right.
And that's something that they can do by just inserting, typing up another paragraph and having an initial by both parties that they consent and agree to this additional term to the contract.
Okay, that makes sense. Let's look at some of the individual parts of a contract in terms of what could be in the contract. Not the general, but now more specific things. We can't cover everything, obviously, in a contract. There's the question of, should I have an attorney? Should I bring something to an attorney? Or should I do it myself? I think that's one question. And then the other one is, what should be in it? If you go to the attorney, you expect many of these things to be solved for you.
Sure. Well, again, in the best situations, Richard, people will come in a couple of different ways. They'll come in with a term sheet, basically a sketch on the back of an envelope that says that I want to do this, and the other party, wants us to do this. So we have this basic agreement, but we need to reduce it to writing, and then we'll add some of the formalities that we've talked about. For example, the term of the agreement, the termination provisions, the payment terms and milestones that trigger the payment terms, the dispute resolution, the forum selection clause that Stuart discussed earlier, how fees for disputes for experts like attorneys and accountants are paid for, things to that effect.
What are some of the major ones that you've seen really trip people up?
Well, probably one of the biggest ones is this forum selection clause, where people are forced to litigate a case, out of state, and as you said earlier, they've lost before they've started, even
Easy to
if
slip
they're
that
on
in.
the side of right, because people see that in the back as just legalese, and it's really not important anyway, or so it's believed, and that's how people get caught. Other provisions that prevent the assignment of a contract when you hire A1 lawn service to do the work on your house because A1 is so good, and in fact, they assign the contract to C- lawn service, and you look out a month after a C-
And they cut
has
bushes
started,
like grass.
They cut bushes like grass, exactly. So you want to limit the assignability of contracts.
Okay,
for
so that's a
example.
good one.
And another thing also to look out for is sometimes in contracts there's basically an indemnification provision, and what that would basically mean is if, hypothetically speaking, the contract would say that if I need to bring a lawsuit against you for breach of the contract and I prevail at trial, then you would be responsible for paying my lawyer's fees. And in New York, or in the United States, basically, and we'll speak more about New York, absent a statutory provision or contractual language, parties basically bear their own litigation fees.
Right.
But if you do have an indemnification provision, that is to some extent a hammer that you could hold over someone's head and say, look, I know I'm 100% correct in this agreement. If I have to sue you or commence an action, I'm also going to be contractually entitled to my lawyer's fees should I prevail. And one thing that you want to make sure as the whatever side you are on is that provision is mutual. Usually, if I see an agreement on an advice role, usually the indemnification provision is only one-sided, and that the side that is presenting to my client the contract usually does not include language that it agrees to indemnify my client. Usually it's just one way. So that's something that you would want to make sure that's mutual.
It's something that could jump out at a person if they're thinking along the lines of, if it applies to them, it should apply. I'm saying that backwards. If it applies to me, it should apply to them.
Exactly.
So that's pretty good. So we have that. You mentioned before termination of contract. It seems like that sometimes would throw me for one, because let's say they say 6 months before the year's over, if it's a multi-year contract, you need to let somebody know in writing. Well, 6 months is a long time.
And nobody looks at the agreement. Typically, with someone, a drafter will put that 6-month term in there when they may not want the other person to have an opportunity to notify them that the agreement will not be renewed. A more balanced provision might be, 30 days before the end of the contract, you'll notify us in writing of your intent not to renew. But if someone is really tied up with a contract, the drafter might want to put such a provision in to make it more difficult for the other party to terminate the agreement.
Before we move on to the disputes, and we want to make sure we cover enough things that could be disputed maybe before we do, but the idea that I can get out of a contract 30 days before seems like something that you would really want to get in there.
You would,
if it's a multi-year thing.
The termination provision, you certainly want to have that in there. Otherwise, you don't want a contract. You need to. If it's a self-renewing contract, you need to spell out exactly how the contract will end.
Otherwise, it could just renew by itself, and by the time you think about it, it's too late.
Right. I think, Richard, you also, just before we started, you asked about what happens in a contract when one party short pays the amount due. And I said that I would answer that question. So
right.
Before we move on, let's do so. A lot of times a vendor will enter into a contract with someone, and the fee for the service or the goods will be $300. And let's say for one other reason, the recipient of the goods or services is not satisfied, is generally dissatisfied, has a reasonable dispute, will tender a payment, a check that says payment in full on it. I mean, we've all seen that. And, the vendor gets something like that in the mail and thinks, well, I've got $200 in hand here. it does say that it's payment in full. If I send it back, I may never get anything. But then if I cash it, I may never get the extra $100. What am I going to do? And under the old common law, when a vendor did cash a check like that, even if they crossed out that payment in full, they were deemed to have had what's called an accord and satisfaction. The accord is the
It's like a little addendum to the contract.
Yeah, right. Yeah, right. It's an amendment to the contract. That's the accord, and then the satisfaction is the payment of money. But fortunately, today under the Uniform Commercial Code, a vendor is protected, and that if the vendor marks above his endorsement with all rights reserved, for example, or without prejudice, then the vendor can still sue on the balance of the amount due and collect that last $100. So it makes it a little bit easier to collect full payment, not have to settle for part payment or no payment.
Good. It seems like we're dealing with two different languages. We're dealing with legal language, which you mentioned sometimes is put in the contract from the point of view of the person drawing up the contract. And the other person might not even really understand what they're signing. You said just legalese. Well, just legalese, as you pointed out, could cost you a lot. So from the point of view of trying to think about a contract as an individual who is not an attorney, the other side of that is asking yourself the questions that could go wrong. It just seems like taking the time to say, what could go wrong here? You know, you read perform lawn services. Okay, what does that mean? And then you realize, well, I have no idea what that means. Whereas if you said cut the grass, you know what that means. So you should have a picture that would really paint what would be the end result.
Enumerate what specific services are going to be performed. Is it going to be cut lawn, rake leaves, fertilize the grass? Who provides the mower, the gas, the tools, the assistants, the bags for the leaves, and so forth? I mean, it's a simple example, but it helps illustrate all the elements that should be memorialized in a contract, so there is no dispute about who's supposed to do what and when.
One more thing that I was almost forgetting, and it just came to me. People get a contract from a larger company. Looks beautiful. All the legalese is there. They might be afraid to actually say, no, I want to change something. How would you react to that if I get a contract and I'm not sure about it, but I say, gee, I mean, IBM or Xerox or XYZ or whatever it is, how can I argue with their contract?
Well, I think a contract like that is called a contract of adhesion. In other words, it's a standard form contract that an individual will get maybe from an auto dealership or from the IBMs of the world, and the terms may not always favor the individual, and entering into a contract like that is at the individual's peril. But I would say that the courts might be a little bit more sympathetic to a dispute under a contract like that, because courts realize that a contract of adhesion doesn't give the party entering in it, the homeowner or the small business owner, the kind of wiggle room that they might like if they were able to negotiate themselves.
So I guess from your answer, there is a certain reality to the fact that if it's a really large company, they don't have time to negotiate contracts with individuals. It's pretty much take it or leave it.
Nor do they desire to.
Or they won't, in other words.
Exactly.
Okay. Now, things didn't go right with either the lawn service, they mowed over the bushes after saying that they would cut the grass, or I forgot that maybe, okay, let's help me with this negotiation part. What happens when we have a dispute?
Well, I think the first thing that happens when you have a dispute is that obviously something's gone wrong. The question is, can you handle it on your own? If you do decide to handle it on your own, what are the steps that you should take or try to take? And if you're not getting anywhere, kind of what are the next steps? I think just like Frank and I said, it's always err on the side of caution in regards to having a documentation in writing. If you're trying to negotiate some sort of resolution to any deals, I think it's always beneficial to keep that in writing. Where, say, you do have a dispute with your landscaper, write them a letter. Tell them what the dispute is. Tell them what your problems are. Demand a response by a certain date. And then see if you can kind of create that paper record or that paper trail. If your dispute with your land person or your landscaper monetarily is, say it's in your $3,000 to $5,000 range, and you're not getting anywhere. He or she's not budging, you're not budging, you know that you've paid him this money that you feel that you're entitled to, or you paid him money for services that he did not provide. What do you do next, so to speak? With a smaller monetary amount, you can go to your local town, this would be the town of Colonie, and commence a small claims proceeding. And there's a very small filing fee. I think it's about approximately $25 or so. And to some extent, it's when people see like your courtroom shows, like your People's Court and things of that nature, where the litigants represent themselves, and there is a judge. Typically, that's kind of what the construct of small claims court is where you present your proof to the judge, your other side presents his or her proof to the judge, and then the judge makes a determination. That's something that individuals can do on their own because it's a lot more cost-effective sometimes to handle the matter on their own as opposed to paying someone X number of dollars to only recover a small amount, and it's your attorney's fees and your recovery is a wash. If it's a larger dispute, and say you didn't live in a residence, but you had a 5,000 acre mansion, and your lawn service bill was $500,000, then that may be in what's the trial court in New York, which is called the Supreme Court. New York kind of has it backwards.
And we have appeals as the higher one, right?
We have the Court of Appeals as our highest court, and the Supreme Court is our lowest court. And that would be a full-fledged piece of litigation where you would hire an attorney to lay out your allegations in the complaint is what the initiating document is called, and you would undergo a process to try to set forth the facts as best as possible for your position. You would request documents to the extent that they exist from the other side. You would have the opportunity to depose or question the landscaper in this situation. And then at the end of the day, depending upon where, what avenue your facts take you, there may be a trial on that issue. And the judge if it's a non-jury trial, or a jury if it's a jury trial, would render a judgment in your favor, and if it was in your favor, you would be entitled to a recoupment of monetary damages, most likely. And if it wasn't in your favor, most likely either you would have to pay something, or it's a wash, so to speak. But it all depends upon the facts of your case and the value of your case as to what avenue you take.
So in either case, Frank's point and yours before, that what you have to work with are case law, the law, regulations, but the contract is really important. So if the contract has been done fairly well, and the person is correct in his interpretation or her interpretation of what happened relative to the contract, you have a good chance of prevailing.
If the ultimate dispute is over the language of the contract or what is contained in the contract, when you're in the process of preparing that, you want to keep in the back of your mind that if I were to give this contract to eight
normal
of my
people?
peers, eight
Okay.
normal people, give this contract to 8 normal people, so to speak, have them read the contract and ask them, what do you think this contract means, or what do you think it entitles me to do? You want eight exact same answers. If you have a different answer, then you know that there may be some ambiguity or inconsistency in there that you need to correct. And I mean, it's always beneficial to use somebody, say it's a family member as a sounding board. I'm entering into this agreement, it says X, Y, and Z. Is that clear to you? And hopefully it is. And if it's not, then you tweak and you edit.
Okay. Yeah, it seems like we talked about before, the amount of money that you're spending seems to, for most people, probably everybody, determine whether you seek legal advice. If I have a contract that I'm buying a $50 item, what's the worst that can happen? I figure $50, right? But if I'm buying a home that costs $500,000, somebody's going to go over this contract. In between, I guess everybody has their, how much is it worth to me to be safe? Do you have a lot of people that you feel make a mistake and they come to you after it's too late? They should have saved their money by spending a little bit of money?
I mean, I think it's difficult to say as far as whether people have made mistakes. Though I may have advised somebody on an agreement, and that's not preventing someone from commencing a lawsuit against them. There is no prevention. We can only put our clients in the best position that if there is a problem, that they are as best off as possible. Sure, sometimes mistakes are made in the negotiation process, and those tend to be in the smaller disputes. Usually in your multi-million-dollar disputes, there is going to be negotiation amongst the parties beforehand to formalize the terms of the contracts. It's in the smaller disputes where there tends to not be that upfront involvement of legal counsel.
And where you may have a manager, for example, of an apartment complex that finds a boilerplate lease agreement that they can use for their clients, and they didn't get any advice from anyone. They just found it. It's been used. It says right there, apartment lease, and they use that. But maybe it was from California, or maybe it's old, or who knows what. So,
actually, I saw one of those recently, Richard, where it was a lease, but unknown to the landlord who pulled the lease off the internet. The lease included a purchase option for the property at a price that was far below market value.
Wow.
And as far as I know, the matter is still in dispute, and the landlord has spent a lot of money, but he did save the cost of having someone draft the lease for him.
So that really goes to show you that if the language is there, and that reminds me of the laundry issue where satisfaction guaranteed. Remember that one from a year or two ago? And it was over just a pair of pants or something? Well, they weren't satisfied, and they sued for millions of dollars because they still weren't satisfied. But it's ridiculous. And yet, that can proceed a certain distance.
Yes, it can.
So I guess we're almost out of time. I'd like to give you a chance to help me out and tell me what I forgot to ask, or make a closing statement that's interesting.
Well, I guess in closing, I think Stuart would agree that if a party wants to enter into an agreement, it's important to spend even just a little bit of time with a lawyer to talk about some of the items that should be in the agreement. Either have the lawyer prepare an agreement or share an agreement with a lawyer that a party's about to sign. But sometimes, even an hour consultation can save a great deal of time, effort, and cost in the end.
And because things are so important, not spending the time on making sure that people really agree and understand, as you said
what
before the show,
to do,
between the four lines, making
do.
it clear.
We like to call, what's in the four corners of the document, because that's what a court is going to look like. Make sure that that what you believe is in the contract is actually in it. If going back to our original example, if we talked about lawn service, meaning cutting the lawn, raking the leaves, plowing the snow, for example, and in fact the final agreement only says cutting the grass, those other terms haven't made it into the agreement, they're probably not going to be part of the agreement because they're not within the four corners of the document. Right.
And that seems like really a good summing up, but I want to get Stuart's help with the negotiation process.
To dovetail what Frank said as far as the negotiation process, if in the early stages your agreement is as crystal clear as possible and there is no ambiguity, you are positioning yourself for a successful negotiation. There's nothing better to point to the four corners of the document to support your case as opposed to pointing to some conversation that did not make it into the agreement. So that being said, as Frank and I think have echoed from the beginning, though some contracts may not need to be in writing, it's always err on the side of caution, and if you have the opportunity to reduce your agreement to writing that memorializes all of the terms, that there's a meeting of the minds, and that it's crystal clear, highly recommended for the success of whatever endeavor that you are going to have, and for the success of any dispute resolution that may arise.
I think that sounds like good advice from both of you. I hope I remember it as well.
Okay, Richard.
I want to thank you for being on the show again.
It was a
Thank you
pleasure,
very much.
pleasure to be here today, Richard. Thank you.
Thank you.
Thank you.
And I want to thank you for watching. I hope you enjoyed the show and that you tune in again next time. Have a great week.
Welcome to Channel 17, the Town of Colonie Government Channel.